Are we all here?
We are.
We are.
Okay, well, we are.
Even more of us than we thought would
It was
be.
really easy for us. We really appreciate you guys making the drive over. And Matt, I don't know if you and your dad or father-in-law, if you flew in just for this meeting or for the game last night, but
There was a game last night.
yeah, there was a game last night. But we're really glad to have you here, and we appreciate the opportunity to share our concerns with you and also some ideas. And we went with the lucky number 7 of both. So we have 7 concerns, a list that we want to go through with you, and then we've got 7 solutions that we think would help move us toward a solution or a resolution. And just because we've had different interactions between all of us, we thought it would be fun to sort of start fresh and call this the Cupcake Summit. And we'll offer you the first cupcake, and we have some plates and napkins, and just pass it around to get us started.
My coffee. But you said it gets hot in here.
It does get hot in here. It heats up pretty fast.
Well,
So
I will be a good sport and have a cupcake. I don't know.
Those are delicious Tammy Co. cupcakes.
Yeah, they'll probably act all polite and whatever. And not taste. So what are these flavors?
So you have the ones with the kind of pastel-colored frosting are Ooey Gooey, my personal favorite from Tammy Co. The red velvet cupcakes, and I think the other ones are
What does ooey gooey mean?
Ooey Gooey is chocolate and more chocolate and peanut butter. And
Okay,
that
what's
sort
the
of
red
stuff.
sprinkles?
That's red velvet.
And what's the white coconut?
Coconut and like vanilla cake.
There you go. If I'm the only one that takes a cupcake, I'm going to be very...
We will not let that happen. Don't you worry.
Clint always has his sweets.
The
You can
red
count
one.
on
I
him.
wasn't going to take one, but I'm not passing it available. I'm sure.
In fact, what we can do
I
is
actually can't. I gave it up for lunch.
we can do one of these. Oh, nice.
You gave up mini cupcakes for Lent?
All sweets.
Here, you can pick some of those
wow.
out.
Friday, Saturday, Sunday. No,
Few
it's
more
not gonna
days.
last.
Yeah, just to go. You're getting close.
Oh,
Okay, great.
Okay, so
All
I
right,
should
so
have
we'll-
brought bigger paper here.
We have everything written down too, so if there's anything that you want to take and think about or something, you
Okay.
can certainly do that. And there, everybody in this room has different levels of knowledge about the concerns that we've had and what we've expressed, and of course there have been some press reports that have been accurate and others less so, and so I think this is a great opportunity for us to really be able to be clear for our parts about what our concerns are, and also to make sure that we're clear about where you're coming from with your position. We have 3 independent concerns concerning the gift clause. And the first is that we're concerned that the $100 million payment to Matthew involves a purchase of parking rights that the city may already own in whole or in part, and the value of which appears to be worth less than the $100 million. The second is that we're concerned that the city is borrowing this money. And the third is a concern that the $97 million management fee over 5 years is extremely excessive and amounts to a subsidy. And all of our questions, our 7 questions, relate to these specific concerns. Pass for a moment. So our first question is really about where the negotiations stand between the city and Matt. So it's great that you're all here today. Yesterday, Craig Tyndall told our attorneys that negotiations with Matt are ongoing and no contract has been finalized.
No, I
but in an
corrected that.
email,
That's not what I said. That was said before. Well, while we're on it, before you go too far, it sounds like you have a long list. That's not what I said. I said that what we were talking about in the context was public records and what would be disclosed and what was protected by best interest, not to get too technical. But I said that the possibility is that we may need to negotiate in the future, and so that because of that, we still have best interest to protect a certain amount of documents from public disclosure.
I'm not
That's
sure
the
that
context.
answers the question that I've got. So let me go ahead and continue.
I wanted to address what you said there.
Okay. Well, that was our understanding, that there hadn't been a finalized contract. But I know also that
But that's correct.
that is correct.
Yes.
Okay. Well, that was my point. And that, Mayor, that you sent an email on April 18th, quote, "A set of agreements were approved by the Glendale City Council in December 2010 and those constitute legal contracts with Mr. Matthew Hulsizer. No one has any right nor authority to negotiate a new deal for the city while an approved one is in place. So our question is, does the city have a final approved contract with Mr. Hulsizer or not?
I think that this may be a matter of semantics. I just heard you say finalized agreement. To me, finalized means everybody has signed off on it. Is that the correct definition of finalized? As far as a city council action, we took an action on December 14th, and as I said outside, a new action would require a change would require new action by the Glendale City Council. So I'm not sure what you're meaning when you say finalized.
Well, I'm meaning finalized from the standpoint of the legal, that everybody's signed off on it. We
That's
have
what I
an
thought.
enforceable agreement, and we don't. But anything that would change substantively in the deal would require, that isn't consistent with the resolutions that were passed, would have to go back to council.
We're saying the
But that's
same
for
thing.
every agreement there is. So, I don't know why there would be a concept that we would do a deal that wouldn't be passed by council. We never have, and we never would.
I guess really the concern is, or the question is, are additional negotiations still possible going forward?
We don't have a signed, executed agreement. I think there's always a possibility of that. I think that, and I was clear yesterday, that these are complex agreements. We'll probably be negotiating for 30 years on various things. I don't think that's unusual. I don't think it's unusual at all in a complex transaction. So, this concept somehow that negotiations are going to stop, we'll never talk about any part of the deal again, is somewhat bizarre to me. But, so we'll discuss it till we're completely done, one way or the other. And I think that's probably going to be a very, very long time from now. So, but as far as the deal and the transaction, I think that everybody's concerned about, until we have a final deal, I think there can be discussions. I don't think there's anything wrong with that.
Thanks for clarifying that.
Good. Do you want to?
My next one is starts generally and gets more specific. Mayor Scruggs, you held a press conference a while back.
Can you keep answering questions? I thought the idea was.
Yeah.
Well, we've put our
Because-
concerns in a list of questions. I mean, that's the best. There are things that we need answers to.
Are you going to provide us any of your ideas?
Yeah. We've got the seven questions and 7
Why don't we just go through
ideas.
the whole thing, the 7-7 thing, because I think we're getting bogged down here, and it may then distort what you have as your 7 solutions. So can we hear the 7 questions and the 7 ideas, and then have a discussion on all of it?
Well, we really want to, I think it's important that we get a chance. I mean, if you really want to hear our concerns and address them, I think if you need to hear the question and then just go ahead
We will.
and answer it.
We'll hear the question.
You want to
and
hear
then we'll
all
hear
the
your
questions?
Yes,
and then,
go ahead.
And then go back to each one individually?
Go ahead. I'm trying to write as fast as you talk.
All right.
So-
It's going to take a lot longer that way, but we're glad to do it.
I don't think it will.
Okay.
It's only 14 things.
All right. Clay.
Okay, so we have...
Well, ask
we
number
have-
2.
Okay, so the first 3 things are all one question, the gift clause. Is that it?
Oh,
No, the
that
first-
was, sorry.
Sorry, the first question was about where the negotiations stand, and it has been answered.
Okay, so that was your question.
Yeah, I'm just saying that what I talked about with our 3 concerns, that's the umbrella for these 7 questions that we are trying to get clarification on so that we
Okay.
can understand.
May I have clarification on number 1, the $100 million payment for parking rights? You believe we already own the parking rights, and there was a second part to your statement that I didn't.
Do you want a copy? We can
Sure.
give you that.
We could follow that along.
And
It's-
we're going to get more specific on that.
Yeah. What I said was we are concerned that the $100 million payment to Hulsizer involves a purchase of parking rights that the city may already own in whole or in part, and the value of which appears to be worth less than $100 million. Do you need any more on that?
No.
Okay. So we'll read you the list, and then we'll just go back through each one.
Okay.
Okay?
The second question relates to public records, and of course we've been in litigation on this for quite some time. Mayor, a while ago you held a news conference in which you said that all of the documents had been produced to us. Since that time, we've gotten thousands of pages of additional documents, many of which go back quite some time, so it's not entirely new documents. And we've also discovered independently documents that are critical to the deal or appear to be critical to the deal that should have been produced by the city and were not. Our big question there is, when can the public expect to have all of the documents related to the sale? The two more specific questions are, in particular, why has the city not already produced to us the same raw data concerning attendance, parking, and revenues from the Coyotes that the city's own consultants used 3 months ago? And finally, is the city willing to give us immediately all records of negotiations between the city and Matt Hulsizer?
Okay. That's question number 2.
Yes.
It's my turn. It's part of the chorus.
Okay.
As you know, we have concerns about the current ownership of parking rights that the city is planning to purchase and use to repay the bonds. On January 25th, 2011, the city signed a contract with the developer of Westgate in which it acquired the right to charge for 5,500 arena parking spaces. This contract should have been provided to us under the existing court order in the public records case, in my judgment, was not. And my question is, why is the city giving Mr. Hulsizer $100 million to purchase arena parking rights it already owns?
You number 4?
No.
Not. We're circling back to that.
And I'll take some turns here.
Not worked your way up to where you get to ask a question yet.
I actually worked my way up out of where I don't.
She doesn't have to ask the question. Exactly. And we're also concerned about the management fee arrangement that you have, that agreement. The original management contract paid the Coyotes manager only $500,000 a year, and the manager remained responsible for all the capital maintenance costs. Paying a buyer $97 million over 5 years to manage the arena, in addition to having the city pick up capital maintenance costs, seems a bit discordant, especially considering the city's own consultant, CBRE, reported that the annual management fee for the New Orleans Superdome would be $5 million over the same time frame. The fee appears to be between 20 and 40 times the going market rate. Did the city competitively bid the management?
My turn again. Whenever ready.
Okay.
Going,
Would you say your last name for me?
Sure.
Because I'm not sure I ever pronounce it correctly.
you know, it's like tomato and tomato. If you say Dranius, I'm happy. If you say Dranius, I'm even happier.
Well, I won't get the but it is the eus. That's the part that wasn't
Yeah.
sure. Dranius or drane. Okay,
Dranius or Dranius?
Dranius.
If you really want to be ethnic, then you got to kind of say Dranius.
Are you getting all this down? Hopefully you have Greek phonetics on your keyboard.
Okay. Thank you.
Oh, you're welcome.
Number 5.
Yes, and this is in relation to our concerns about the raw data being supplied to the consultants. We're concerned about the reliability of the findings of the consultants the city is relying on. And the reason why we have some of these concerns is we've had reports given to us that Walker Parking Consultants settled for $1.5 million or thereabouts some federal litigation that accused them of inflating revenue projections related to parking analyses that they prepared in conjunction with a municipal bond transaction for the purchase of parking rights. So the bottom line is, how can we and the taxpayers trust the data the city is relying on in its consulting reports?
And there's a follow-up.
Oh. Oh, well, yeah, then this is pretty significant. We've also received the report, and this appears to be reliable, that the Seattle transaction involving these municipal bonds, in which Walker was involved as a consultant, were found by the IRS in a preliminary and final determination to have actually violated the rules required to maintain their tax-exempt status.
So based on the Walker study.
Yes.
So therefore, Walker studies are.
It just raises questions, and it goes back to why we haven't seen the raw data underlying those consulting reports.
Is tax exempt part of the gift clause? Tax exempt versus no tax? No.
No, this is a
Just
unrelated.
just the fact that the people we use
I keep forgetting to
Are
turn it
we
off.
insurance?
Could be
are
part of it.
making up data. By the way, where is this from? From Seattle?
That's right. There was a Seattle transaction involving municipal bonds for parking.
Fix it.
You know, and I said, we're not going to answer questions, but it says right in the CBRE analysis that they did not accept the Walker findings.
That
And,
wasn't all we used, right?
pardon?
That wasn't all we used.
They took those and they took some other study and they said, well, no, this is what we think is real. So that's not even the basis of anything. But I digress, and I said we want to finish all this.
And I fully appreciate the fact that there are multiple consultant reports, but I hope you can understand why we need to see the underlying raw data.
Actually, whether there's multiple or not, the one that took the bonds to market is the CBRE market valuation. Isn't that correct? And that's the one I'm getting out of my area.
The other concern is that these
I'm
are
sorry.
tax-exempt bonds, and in what appears to us to be a similar transaction in Seattle, the IRS appears to have found that they were not tax-exempt because of the nature of the transaction.
Yeah.
Okay.
Because of the parking study, or was it unrelated to the parking study?
The parking study issue was part of the overall transaction, but the IRS determination dealt with the private business activity restrictions that are placed on maintaining tax exempt status. And so there are other permutations of this report that may or may not impact how Glendale is structuring its bonding, which we're not yet asking any questions about because we just don't know enough about either the Glendale transaction or the Seattle transaction to pursue that. But we do have an intense interest in the underlying raw data relied on by your consultants.
Okay. The press has widely reported that the City of Glendale plans to sue the Goldwater Institute for exercising its First Amendment rights. And on March 5th, 2011, one of your outside attorneys sent us an email stating, tonight the city decided that they could do nothing but to bring a lawsuit against GI and board members for several $100 million. Did your outside attorney correctly represent what occurred?
Who would that be?
Jordan Rose. And we have a copy of it with us if you'd like to see it.
And what did she say?
Tonight the city decided that they could do nothing but to bring a lawsuit against Goldwater Institute, board members for several $100 million.
I guess that's a question for
We have
Jordan.
copies right here.
I know that's a question for Jordan.
Well, did she correctly represent what occurred? I mean,
We'll move on. Now we're going to do all 7.
okay.
And last but not least, we understand that the Tohono O'odham Nation is interested in helping privately fund the purchase of the coyotes. Will you consider negotiating with them to protect taxpayers and keep the coyotes in town? What has the city done to seek out private investment to replace public funding for the sale of the coyotes and the management of the arena? And that's our set of concerns.
Lucky 7. There
Now
they
we have
are.
the 7 solutions.
And you've got those. Yeah. You know what? Why don't you just take one and pass?
Do you want to present for this guy?
If I had a copy, sure.
Oh, you do now. Thank you.
I don't know that they need to be. I mean, we can state them into the record, but everybody, as long as Julie, if we
Yeah,
can
I
pass
just needed one more
copy
please.
down for her, we'd be good.
Thank you.
Well, if you want me to read in the record, or
Please.
Okay. These are steps that could help the city move towards a resolution. 1, use private money to finance the Coyotes transaction, such as having the buyer purchase the team with his own money, adding additional investors willing to share the risk, or partnering with the Tohono O'odham Nation. Incentivize the transaction with regulatory flexibility rather than taxpayer money. Number 2, competitively bid the management of the arena or reduce the management fee to a plausible market value. Number 3, securitize the 30-year projected revenue streams to the city from the arena lease, parking, and management, or if the amount that can be obtained from securitization is minimal, obtain 100% collateralized guarantees of revenue streams from the arena lease, parking, and management. 4, adjust arena lease payments to real market conditions. 5, lease the arena to a minor league team that does not require a subsidy. 6, reduce losses by finding a private buyer for the arena. 7, require the NHL to be a party to the Coyotes non-relocation agreement and perform due diligence to ensure that the NHL franchise rules do not render the agreement unreliable.
Okay. I would like to make a statement. Most of what you have raised does not come under the duties of a mayor under the council manager form of government. I assume you're all aware of what the council manager form of government is. So the questions you are directing to me are not questions that I will be answering. Under the council manager form of government, the council is the policy maker. We set policy. We give direction to management to implement the policy. So the direction took place on December the 14th, 2010. I don't go negotiate new deals that I then bring to myself for approval. And that is not the way that the council manager form of government works, nor is it anything that I could be allowed to do under our city charter, nor any other city could be, the mayor could be allowed to do that. So in other words, I could be brought in violation of the city charter for violating the council member form of government. But that's not the statement. The statement I'd like to make is almost 2 years ago, we're probably 2 weeks shy of 2 years ago, when the City of Glendale got the surprise of our history, probably, when we got a call saying that Mr. Moyes had put the Coyotes hockey team into bankruptcy. At the time he instructed his attorney, Mr. Earl Scudder, to do that, Mr. Bettman was on his way to Mr. Moyes' office to work out a potential sale of the team. Mr. Moyes no longer wanted to own a hockey team. Everybody knew that. There had been work being done with the NHL so that he could sell that team. And my understanding is that Mr. Bettman had arrived in town to work out the details of that sale. And as he was getting off the plane, he received a call from Mr. Moyes, "You don't need to come out here. I've put the team into bankruptcy." From that point forward, in May of 2009, the City of Glendale has not been in control of the situation. Timelines have been set by others. Bankruptcy court, the National Hockey League, prospective buyers. And we have done the best that we can to respond to the situation in the timelines that have been given to us. We know that the team needs to stay in Arizona, in Glendale, Arizona, in our arena. We know that is the very best solution for our residents, our taxpayers, and really for the entire region. The jobs are important. The revenue that's brought in is extremely important. The viability of all the businesses in Westgate and the future for businesses to come once our economy recovers will be thrown out the window if the landlord is evicted. So we have done the best that we can under each timeline that we've been given. Along the way, we have had several prospective buyers emerge. And they have all had different types of arrangements, deals. I hate the word deals, so I'll just tell you that up front until I can come up with a better one. But different types of agreements that have been proposed, brought before the city council, approved, not approved. Of all of those buyers, singular and repeat, the best buyer that has emerged is Mr. Matthew Hulsizer. He is the best buyer not only of the crop that has come to purchase a team, but the ones who have owned it in the past. And I will tell you why I firmly believe this. He is a proven businessman. He's an accomplished leader. He is a person who stands on values. He's not out here to get a land development deal. He knows the sport inside and out and is one of those people that has some great attachment and affinity for something that the rest of us find hard to follow and on any given time. He truly believes in it. His goal is to build the best franchise there can be. He has studied everything that has happened in the past and knows why the team was not successful under the previous owners and knows how to fix it. He and his entire family, his father-in-law is here, have committed themselves to Arizona. I don't know that they're going to move their permanent residence, probably not, but they all are going to purchase homes. He wants to be an active member of the Arizona business community. For those reasons, he is really the best owner for that team, the best owner for a business, a viable business. I'd like to say here, hockey is business. People like to call it a sport. Well, all the other sports are businesses too. And they all have owners and they all bring value to the community. But this is a business. I think, especially in these economic times, there would be a great uproar if a major business that brought in the kinds of money that the Coyotes does was going to leave. There'd be a major uproar among the business community. We can't let that happen. Well, I don't know why this particular business is okay to shove out the door, but the reason why I'm telling you this story, quite honestly, or this background, quite honestly, is that all of the ideas you've presented to us assume there is unlimited time to go and work through these various arrangements. They also assume that they're feasible, which some of them, quite frankly, are not feasible. I'll pick out two. The minor league hockey team comes up again. 5 times there's been a minor league hockey team in this valley. It left in 2009. Its average attendance was 3,025 people. There are complaints raised, which I don't understand, about the Coyotes, which have an average attendance for this season with all the hardships and all the uncertainty about whether there's going to be a team here or not, average attendance of 12,208. That puts it at the bottom of the pack, you might say, or some might say. It fills our arena on the average. The average fills our arena 71.3% of the time, or 71.3% of our arena capacity is filled by the average 12,208. I would suggest you might put that up against some of the other sports enterprises in this valley. I can think of one in particular that does not fill their just under 50,000 seat stadium, even 50% of the time on the average. So to go to a minor league team then, when a knock against the Coyotes has been, well, they have such low attendance, so we're going to go down to something that would bring in 1/4 of that attendance and be viable for our citizens in helping to keep the arena open and pay all the expenses. We know there are huge expenses. That's documentable. We know that it costs a lot to keep that building open, operating, functioning. So that really is not a viable idea. But let's say it was. Let's pretend it was viable.
Well, I think,
You
Mayor
assume-
Scruggs, if I might, just to remind you, nobody said each of these would solve everything. These are just steps, to consider
But
that
some
could
of-
help and be helpful in the resolution.
Okay, so then we get back to time. Okay, the time to actually secure this, and you're assuming there's a team available that wants to come in and that they don't want any sort of investment in the team or incentives. All the while, the City of Glendale is paying the cost on ourselves to manage that arena without the revenues coming in. Now, I would like to address one that's particularly troublesome, and Craig probably will want to assist me in addressing this. Particularly troublesome is this idea of partnering with the Tohono O'odham Nation, which you have been successful in promoting through a very small group of members of a group called the Glendale Tea Party
We
Patriots.
have not been promoting that idea. We have not been promoting that. These are ideas that we're giving you as possibilities.
I
but-
would like to talk about partnering with the Tohono O'odham Nation. They have attached a condition to their partnering. That condition is that the City of Glendale drops its lawsuit. That could be considered blackmail, couldn't it, by some?
It's lawsuit against the Goldwater Institute? Or what lawsuit?
The condition for the Tohono O'odham Nation to assist us, as it has been put to us, to me personally, by members of the business community and others that are promoting this, is the Tohono O'odham Nation can solve our problem with the coyotes, can get the Goldwater Institute off our back. All we have to do is drop our lawsuit
Against the
Sorry.
Tohono.
against the
Thank you.
Tohono O'odham Nation. That's not a very, well, does that pass any kind of smell test or anything else? No. But beyond that, let's say that we were unethical enough that we would consider something like this. Tom Horn stated Wednesday night at a Pachyderm Coalition meeting that the Tohono O'odham Nation's action to establish a casino is in direct violation of the Arizona Gaming Compact. It is illegal, that he is committed to using his full resources, the resources of the state, to continue to fight this. Ask members who were there. He said this publicly. It was reported to me that he stated this. He fully supports the City of Glendale. He stands with us. So the Tohono O'odham Nation's proposal, if you want to call it that, to engage us to violate the law, really wouldn't get them very far, because they have many other serious problems.
A quick question. Did the federal district court agree with Glendale's analysis of the legality of this?
Would you answer that, Craig,
Well,
please?
I'd be happy to, but I have no idea what the relevance is, but just out of interest, I suppose, is no, they didn't, but it is up on appeal.
No, the court did not talk about casinos, though,
Well, that's true, but your question was
because they
related to
don't
casinos?
feel they
Well,
need to have any approval.
Exactly, there was no gaming, application. I'm trying to boil this down because it can get really long-winded. When we went to court and the tribe had removed their gaming application from their application with the Department of Interior, gaming wasn't part of their application. As a matter of fact, what they said was that they didn't think they needed gaming approval under IGRA, the Indian Gaming Regulatory Act, that they could just come in and start gaming, which other tribes have tried, and other tribes have been shot down. Just recently, as a matter of fact, that is in fact not the case, and they have since resubmitted their application. But so it wasn't an issue at all in the federal district court. So all of his issue in federal district court was a determination as to whether the land could go into trust under the Gila Bend Act, and that is up on appeal now. He has a file that
Thanks, Craig.
I'm sorry to interrupt. Is there a philosophical issue with the casino in Glendale?
No, there's an issue. The city has always said that it isn't opposed to Indian gaming or gaming in general, because we understand how it's developed in Arizona and what it means for the tribal members. But we have grave concerns about a reservation being created in the middle of Glendale and all that means. So that's the biggest problem. And of course, to do gaming, you have to have a reservation, because you can't do it otherwise. So
Would there be anything else on the reservation, or would it
there
just
could be anything on the reservation.
Anything,
That's
right.
the problem. There could be completely, and there's no control by the state or the city whatsoever.
Great.
And I
appreciate
can address that with Chairman
Mayor.
Norris in the very beginning. It's important to state for the record that the resolution of the City Council adopted in April of 2009 is opposition to the creation of a sovereign nation, an Indian reservation sovereign nation, within the municipal planning boundaries of the City of Glendale. And we tried to address, when we thought that this was a mandatory taking, which it is not, tried to address those issues early on, and Chairman Norris is not interested in addressing the very serious issues that arise if you have a sovereign nation in the middle of your city.
Thank you. We are already 45 minutes into the meeting, and
But
we've only
Mr.
gotten.
Templer said this could go all night if we wanted.
Well, it could if you wanted to.
I read it in Rebecca Sanders' article that Mr. Templer said this could go as long as we wanted.
Well, it certainly can on our parts, but we
Yeah.
figure you probably wanted to keep it to an hour and a half. And we so far only have one of our concerns addressed here. We've got 6 more that haven't been discussed at all, and we'd really like to get to
Could you ask
those.
Mr. Hulsizer and Mr. Capoletta if they would like to address these, because some of these clearly go directly
Well,
to you.
these
They're not
questions
business.
really we weren't expecting, Matthew, and so
Neither
and
were
we've
we.
had a lot of communication. These questions really are for the city and about what the city plans to do with taxpayer money, and so we want to make sure that we have answers to these, that questions that taxpayers are asking and that they need resolved. So
And
if
we
it's all right with you,
understand your perspective,
we'd like to go back to some of these concerns and see if you could address some of them.
Well,
I think I could answer all 7.
Go ahead.
Well,
Five
I think taxpayers actually need to hear this from the city officials themselves. I mean, this is their.
In regards to my transaction, I can
Well-
tell you how we thought of it, because there may be
That's great, Matt,
some
but
other buyers.
if you would, taxpayers want to hear from the city.
You know, Ms.
So-
Olson,
why don't we just
really,
let them talk?
we have
How
3
about that?
parties in this. One is Mr. Hulsizer, one is the National Hockey League, and one is the City of Glendale. And a lot of what you're asking is Mr. Hulsizer's business, not City of Glendale.
Actually, all of these are questions that the city
Yeah,
of Glendale
and
needs to answer for
I
taxpayers.
I understand your position. I think we all understand your position. We understand your agenda
So you don't
completely.
want to answer the questions.
We understand your agenda completely, but there are other people at the meeting, and we'd like to have the meeting conducted in a way that
You have
is
not
conducted
allowed
for
us to
everybody
talk
else.
about the
So-
taxpayers' concerns if the tenant is evicted. If you could allow him to speak, and I'm afraid you don't want him to speak because this transcript will be made available.
Matthew and I have
this is-
spoken many times,
And
so
that has
I'd
not
love
made,
to have him talk.
and that has not made
our
it into
concern-
the general public.
Our concern is to make sure that the questions that taxpayers have for the city be answered, and that's what we understood you were offering today, was to hear our concerns and
Well,
address
let
them.
me
So as long as we
address that.
get there, we're in great shape.
Let me just address that, okay? Because I set aside 2 hours yesterday to address a lot of the questions that were put on the table here. And I made it very clear that I'm available to answer questions at any point in time. And I'm happy to have an ongoing dialogue about this. So and I made it very clear twice during our meeting, or during our telephone conference, rather, that where we were coming out was to listen to what ideas you have, and you presented them, that's fine. But we're not here to be interrogated in the least. And I understand your position, I understand your agenda, I understand why you're grandstanding over the whole thing. I got it. But I'm telling you, we'll answer the questions perfectly fine. To all of our
Craig, I
taxpayers.
think you could use another cupcake.
For all of our taxpayers, we'll gladly answer all of the questions that they come up with, our taxpayers come up with.
Well, that's
And
why
that's-
we're
and
here
that's
today,
fine.
is to
And
try
a lot of
to
these
get
have
these
been.
answers for
No,
taxpayers.
a lot of these have been answered. I talked with Nick for 2 hours. Diane was in the
It
meeting
should be
part of that
easy to
time.
answer
I
on
would
that.
like
So I
them
don't think
answered
this
for the
means
record.
appropriate.
Number 1, use private money to finance the Coyotes
Those
transaction,
are
such as having the
suggestions,
buyer
not
purchase the
questions.
team with his own money. That's a question for him.
No, the concerns, we have 7
Well, I think-
concerns,
and I think
and we've only had one addressed so
Well,
far.
the first and the last, I think, were both. The status of negotiation.
And these, I'm
Okay,
sorry, but
all
these
right.
aren't for the buyer. These are for the city who's
That-
responsible for spending the
You're
money
right.
and setting up the deal.
You are making
How about
a
But
political
do
statement
have your-
that does
do-
not
do-
match
do
reality.
say what you-
Okay.
I don't need to be here, then you guys can fight it out.
Yes.
Whoever comes out wins. Okay. Status of negotiations. Nothing signed yet. I concur. That's why we're here. Help us. Public records. I have no clue why you guys are dropping off data and documents, and I told you this. Now, I mean, I don't get that. So that should have been done, and you know that. And we don't see eye to eye on this stuff. I don't know why you're entitled, and as taxpayers are entitled to transparent government. And whether they got the wrong documents, or sending too many documents, that should have been done. Okay, you get them. We have all the documents we need, right?
Oh, yeah.
Okay, so parking rights are owned by the city. I can't answer this, Jay. I mean, we don't see that. I think it's complicated, but I think, you know.
Right, it is complicated. But basically, the arena manager and team get the parking rights 2 different ways. One of them was through a parking, I can't remember the exact name, but a parking mixed-use development agreement with an entity controlled by Steve Elman. And I think that's 2,600 and some spaces. And that's a contract that the bankruptcy process is ongoing, but that's a contract that can, the team would assume there was a consent requirement under that. We have assigned consent from Steve Elman to allow the transfer of those parking rights to go from the entity that we're attempting to buy back to the city as part of the transfer of rights. So that's one set of the rights. The other set of the rights goes back to the original 2001. I'm going to get the nomenclature wrong, but Amula from 2001, which again had been, it's kind of hanging out during bankruptcy, but we get the rights to land that maybe the city may own the dirt, but they conveyed the rights to control, operate, and get revenues from parking from to the team 10 years ago.
Okay, so that's our view. I don't know. We're just the tenant. We're just the tenant. We're not the landlord here. The management fee, competitive bid. I think this has been in the public eye for 2 years. If there is a person out there who wants to do this and enter into this arrangement that has not heard about the availability, they should step forward. We've said from day one, I know you went to TV and said, look, we're looking for another buyer. I'm perfectly happy. I will not be sad. I'm in the investment business. If there's another buyer out there who pays $1 more than us, they should buy this team. Absolutely, because that is the free market. And I'm a big believer in the free market. The free market has set the price. At least 20 people have looked at this and said, they've offered them deals. This is where we are. We offered them the best deal. As far as we know. Again, I haven't seen all the deals. I've seen a couple.
Matt, does that go for the management arena deal as a separate?
I'm happy to walk you through it. And one of the things, I could walk you through the details of running the arena. And my suggestion would be, what should the cost of running the arena be? The cost of running the arena should be somewhere between 12 and 18 million. Okay? Now, let's assume that we're wrong on our assumptions. Today it runs a little over 20. It's not well run. It's been in bankruptcy. It needs to, and it comes down. That's why the management fee comes down. If we're wrong and we run it really efficiently, the city gets the profits. If we miss on something, the city gets the first $5 million. Everything above 50 in the first, right? That's why it's set up in a certain way. The first $5 million goes to the city. It doesn't go to us. We're not trying to make money on running the arena. It's expensive. Power in the desert is not cheap, nor is water. Engineering, these are things that really cost a lot of money. My suggestion is, in your diligence, I think you guys know Ken Kendrick. Okay? He's running a facility that doesn't operate 365. You should ask him what he thinks it costs. I talked to him. Okay? He thinks he's going to cost him $12 million. Us, it should cost 15 because we're running 365. We still have to book concerts way more than they do at Chase Field. Okay? So it's a little more expensive, but that's where it runs. And if it makes money, it goes back to the city. That was the entire philosophy behind it. It certainly is not a gift, because if we make money, it goes back.
Matt, let me just ask you this. How do you explain then that under the original Amula, with the original team, they were being paid $500,000 a year, as opposed to your deal?
That's why they're bankrupt. That's why we're here. It doesn't work.
That's a 10-year-old agreement that doesn't exist anymore. I don't understand why it would have any relevance.
Wait, I thought you didn't want to answer the questions.
But in supplementing his response, I will tell you that in the bankruptcy court there was a competitive auction. That was one of the things that went through in the bankruptcy court. We had an auction for this team, and there was one bidder at the end of the day.
Now, Craig, you know as well as I do that the auction was for the team and not the management side of the deal. So let's be clear about our terms.
You're absolutely correct.
The concern I have, Mr. Hulsizer,
but
the concern I have right now is that all of your consulting reports, and particularly CBRE, highlights the current going rate for management contracts, ranging from gigantic arenas like New Orleans Superdome to tiny arenas, and none of them come within a fraction. I mean, come within anywhere near the amount of money that
are they responsible for the day-to-day costs? There are lots of flavors of management fees. There are management fees that are paid just to manage the arena. There's management fees that are paid and then the manager takes on the responsibility to run the arena and the cost. That happens to be our case. So there's lots of different ways to do the same thing. So comparing apples to apples would be pretty important, Nick. I don't know if that's been done.
Again, I offered you guys this 4 months ago. When I sat in here with both, I said, I'll walk you through every single number. If you think you can manage this arena better, I got a job for you. I'm happy to do that. This is a free market. If you think that, but there isn't somebody who's willing to do that because it's just really expensive right now. Part of the problem is, and you'll see this in sports accounting, people move things left and right. However New Orleans wants to do it, they say, look, we've got people who manage the engineers, but the engineering isn't really part of it. And I don't know the Superdome's business, but I do see the other arenas. And yeah, ours is too expensive. No, I'm not arguing with you. That's why the fee is set up the way it is. It declines.
Well, I guess the bottom line is, has the city ever considered sending out an RFP to manage the arena?
That's part of the lease, though. Right? You could break it down and say, who would like to take the advertising?
So there's no RFP, essentially.
Well, there's an RFP for the lease, for the team and arena manager, the team and the arena manager.
I have a question though. Does the gift clause require competitive process?
No.
What the gift clause requires is that you do not have grossly disproportionate consideration, or you could flip it around and say roughly proportionate, or
Not
argue in
can't
between
flip
the
it
two.
around. I think it's grossly disproportionate. That's what the Supreme Court says. It doesn't say roughly proportionate anywhere.
Well, the bottom line is it's arguable the exact extent to which it is proportionate in the consideration. And part of the argument there is going to have to look at the reality of the market value, of the rights being granted, and what's being paid for them.
Yeah, out of the entire transaction.
Completely agree.
Out of the
Yeah,
entire
so
transaction,
completely
you got to
agree.
look at the entire transaction. So that would be a good thing that you should do, is look at the entire transaction that comes out of the entire consideration that comes out of the agreement.
Do you feel like
and do
there are
that
people who
analysis.
haven't heard about this?
Well, just to touch real quick on your question, Jay. The courts have come out and said in the context of the gift clause that an important factor is considering whether there is competitive bidding for something, and it is relevant if there is not.
Do you guys feel like there is somebody else out there who has not emerged, some yet person to emerge, who is going to say, I'm going to do this, but I'll take $500,000 to run this arena despite what the costs are?
Matt, we can't know that, and I don't think
What
the
do you
city
think?
can either.
You know,
Let me
it's not judgment,
let me
though.
just finish
What do you
that.
think?
I'm trying to answer the question. We don't know that, and we can't know that if there's no competitive bidding. I mean,
There's competitive bidding
there are,
for the entire piece. There's competitive bidding for the entire piece. If you want to take out a specific cost, if you want to tell me that the hot dogs are overpriced in the arena, and you know, and we should competitively bid that, and that constitutes the gift, I don't know. I can tell you that as a matter of course, as an entire business, as a package, this has been competitively bid. No one else has emerged, as far as we know. The city may know of other buyers. You may know of other buyers. But in the free market system, as far as we know, we have the highest bid.
Yeah, Mr. Hulsizer, let me just clarify, from a gift clause perspective, competitive bidding is just one way to potentially avoid a violation. It may very well be that you have a completely non-viable business, and nobody will assume
Totally
that
agree.
business without
Okay.
subsidies.
I-
And so our argument here is, if we look at every component of this deal, whether we look at it panoptically or we look at the individual components, all we see is a series of things that do not make market value sense, which look like an effort to prop up a business that is not sustainable, and that is why you may be one of the only people out there stepping up to the plate.
Totally.
But
Your argument is, in fact, it's not viable business. It's not that it wasn't competitively bid. Let me be clear, because it was competitively bid. What your argument is that despite the competitive bid, it doesn't matter. If you competitively bid for a painting, you're saying it doesn't matter. It doesn't make economic sense. Is that?
Well, I'm saying that it could. There has been no official competitive bidding. What happens by word of mouth
What
is
was the
not.
bankruptcy auction?
Well, that was only on the particular assets in the debtor's estate. That has nothing to do with the overall competitive bidding of this particular contract. All we can say is this: that hasn't happened. You have
Well,
your
I don't
opinions on
think
whether.
I think it has happened.
Okay.
We've had this thing out 2 years. Everybody in the entire world knew that there was an issue here and they can come in and buy a team. We've talked to lots of people. Sometimes it's a complete waste of time.
Yeah, I'm sure that
Quite a few of them, a complete waste of time.
He's
Everybody
not
came up
wrong.
there.
Hold on, Nick is not wrong though. You have a legitimate point. You're concerned whether or not the business is viable. Correct?
Well, I think that seems to be a likelihood from, 16 years of this business losing tens of millions and
And
hundreds
so
of
why
millions
want
of
to
dollars.
know, what are you basing that on? How do you, because you know what? You never asked me. You never once. I've seen you guys for 4 months. I came in here, I said, I'll show you any number. You don't know. You read in the press. This business made money. This business made money in 1999. I'll introduce you to Richard Burke. He made money on this team. You just didn't bother to ask. You never bothered to ask me.
Well, Mr. Hulsizer, we have asked the city for all of its evidence of due diligence, and we've been told that it's all proprietary and they can't give it to us. So if you're willing to make things like that available, I'm willing to look at it.
Well, no, wait a minute. That's you jumped topics there when you said something about due diligence, and you've asked about due diligence. We had a long discussion about due diligence, and I said that the city did its due diligence on Mr. Hulsizer to ensure that he was a viable buyer, which we did on everybody else that came in. All right, that was the due diligence we did. I think Matt's talking about something different. He's talking about your comment that whether this team is viable or not, which has nothing to do with due diligence, and whether or not you ask the number before you make the statement or ask the question. And apparently that was never done. So, it has nothing to do with due diligence, Nick, or what the city said about due diligence.
Craig, the problem is, in a court of law, if you have a business that has lost money for over a decade, as just emerged out of bankruptcy,
That's an assumption.
and you're replacing it with a no-track record entity, headed perhaps by the most dynamic entrepreneur there is in the world, you're still not going to be able to prove that that's going to be a viable business.
And
Nobody
wait a
would
minute.
accept
What-
anyone's opinion in a court of law that that's a viable
And
business.
what lawsuit is that?
Okay, we're getting a little bit bogged down here.
Why don't you
So
just ask me
now
about the
let's
business?
keep going on whatever else you have. I don't want to spend too long on just one thing. There's a lot to talk about. So why don't you keep going?
Okay. It doesn't have to be adversarial. Like, I'm willing to be totally transparent with you. I'm upset that you guys have said this, and I've been willing to do this the whole time. You might be right? You might say, look, even if it loses, I know what the losses are, and I can fund those. And I'd be willing to do that.
Well, Mr. Hulsizer, if the burden of this deal is placed squarely on your shoulders, and 100% on your shoulders, and in a way that's fully collateralized, that is a step towards a resolution.
I understand that. I understand your view on that. Okay. Reliability of consultants. How can we trust the data? And I don't think we used Walkers in our study. I certainly wouldn't have used them. Right? Walkers came up with a value that was much higher. I think $100 million for parking has never been what we assumed.
Well, that's right. I mean, the 100 million was never parking alone. I think everybody here knows that. The 100 million was, parking was a big part of, but the 100 million covered everything that is the bundle of rights under our transaction, the non-relocation agreement, the arena put right, everything, all those revenues, all the revenue streams. The four corners of the documents have a lot of different agreements that we, as the buyers, are making for the benefit of the city. And it's not just, like Matt was saying, it was not just 100 million for parking.
Did Walkers inflate the revenues? I don't know. I mean, I have no idea. The fact that you're concerned about it, I think it's a valid concern because it reflects on judgment. The data wasn't used, so I can ease your concerns there. The Walkers data was not used. But it does reflect on the judgment, and I think that the city has to own up for that. Maybe they aren't great at picking consultants. I think they rebounded from that, but you didn't pick the best consultants first. I think it's a valid point. Okay.
Well, just since it's recorded, we'll dispute that. But go ahead. Keep going, Matt.
Okay.
You can't answer those 6 lines.
Suing the Goldwater Institute. I don't know anything about it, but it is the Indian tribe.
They trust them.
Yeah, that's
That's
unless you want to weigh in, we feel like that
I'd
was
love it if the
addressed.
Indian tribe could do something, but we're going to disagree about that too. So, but yeah, if the Indian tribe wants to put a casino in, we have no issue with that officially.
Great. Thank you, Matt. Jay, did you have anything you wanted to add?
I don't. I mean, there may be some when we get back here, but that for now.
You're,
Great.
you get a couple of things in here. You number 3, and one of your solutions, and you guys, I like some of your solutions. Obviously, the first one we talked about, competitive bidding arena. I think we've talked about that. Securitize the 30-year projected revenue streams. This comes down to the crux of the issue. 100% of the reason why I believe we are here. The city has already securitized it. They did that to build the building. Unfortunately, the person who was supposed to pay them was not able to pay them. They counted on Mr. Moyes and the team to succeed. That didn't happen. They've already sold those payments. This is like taking, this is your second mortgage. Our second mortgages make sense? Sometimes. It depends on what the value is. And so if you look at the net cash going out, which is what I continue to talk about, the $75 million, which is the thing that I went on and said I'm prepared to guarantee. I will guarantee for sure, it is a mathematical certainty that we will pay the city back more than what they will spend, okay, in terms of $75 million, because we already pay the city as part of the lease millions of dollars, $5 million a year. That goes away when this team leaves. $75 million. That's a piece of cake because the money we pay the city is currently servicing other debt the city took on. Wrongly or rightly, has nothing to do with my deal. So in regards to my deal, the money we are receiving from the city will be more than offset by the money we pay the city. I cannot comment, and I will not comment on what the city has done in the past. I think they can do that. Adjust arena lease payments to meet real market conditions.
Discussed.
That's discussed. Lease the arena to a minor league team. The only thing I would tell you guys here, we have a minor league team, San Antonio Rampage. Okay? It's not just the tickets, it's not just the 3,000, it's the price. This is all about price and price points. A minor league team is going to charge somewhere around $9 a ticket. They can't pay a lot of rent. I know. We lose money on our, great thing would be if one of you guys could take over our minor league team. Our minor league team loses money for us, and a lot. It's just not a good business. It's certainly not a good business in an expensive arena to operate. Reduce losses by finding a private buyer for the arena. I think I am going to be the buyer of the arena at some point. The question is, we're going to argue about price. It'll be in 30 years, but the city's going to get some money for it when it's beyond its useful life. The Silver Dome, if you guys Google the Silver Dome, just sold, I don't know, has ever looked at that? Silver Dome cost $500 million in today dollars to build. They sold it for $500,000. That's what happens when arenas go to the end of their useful life. Maybe. Could also be Madison Square Garden. I hope it is. We all hope it is. I'll be really successful. And you guys will say, oh, it was a gift. It's 30 years later. But who knew that Glendale was going to overtake New York City in terms of population? Right? That could be the case. Who knows? I can tell you that in 30 years, it's a fair market, and the city will recoup some amount of money between $40 and $135 million for this arena. That has some value. And so I will end up being the owner of this arena. This team is going to be here forever.
Can I ask you, the numbers you said, 40 and 140 million, how do you figure that?
It's part of the lease.
It's in the document.
Is that the put option number?
Yes.
The put option actually says the lesser of what you mutually agree on at 40 million.
No.
Yeah, that's what it says.
That's the arena. But yeah, you think that's the arena. There's some.
It also
There's the
has
land.
outstanding,
Well, hopefully we
it
don't
also has
really
outstanding
low
bond
value.
obligations in there.
Okay, I assumed it was 40. I don't know why they'd ever agree to less, but maybe they'll be generous.
40 is the floor.
Like they have been, right?
40 is the floor.
40
is
40's
the
the
floor.
flooring.
Oh, I thought
for 30
the
years.
lesser of, you just said it's the lesser of 40, what we mutually agree on.
Yeah, the 40 is the floor.
Well, no, see,
But
the
there's
lesser
other
of-
there's other ways of.
So why in theory, we could agree to less. That's what he's pointing out. We could agree to $1 million. Is that correct? That's what you're
The
doing.
puts 40 or outstanding obligations or what we negotiate. So it could be.
And Matt, down here.
I
Diane.
am Diane Cohen. I don't think we formally met, but I wanted to thank you for taking the time to come here and answer almost all of Darcy's 7 questions, even the ones that you probably don't have the foundation or knowledge to answer. So I really thank you. Mayor, you've answered one, And I would ask you now to answer the questions that Darcy had directed to you.
Are you
Well,
through presenting your information, Matt?
Yeah, the last one, by the way, is the critical one, because I think you guys,
It ties into Nick's concerns
Yes.
too.
The reload?
let's talk about I'm independent, nothing to do with my transactions. I'm going to weigh in here on an opinion. It does not affect my transactions. In 2002, you guys signed a lease, and it's not as part of the lease, there was no non-relocation.
Yeah,
It was built into the lease.
Yeah, we had a reload and non-reload.
Oh, sorry, so it got thrown
That
out.
was the problem.
It got thrown out. That,
Well, okay.
Yeah.
Or
It was part of a real estate
potentially
lease.
could cap. It's never been decided.
that, and we argued about and talked, I mean, we don't agree on this. That was a fundamental mistake. And you cannot admit that now, or you can.
Okay, I won't admit it.
Well, okay.
I didn't do that lease, so I don't have to worry about it.
Well, I mean, that's a big mistake, because the team,
Well, the point really is that we structured the non-relocation agreement with, the city had a role in it too, but the non-relocation agreement was structured with the experience of the Coyotes bankruptcy, as well as, even more importantly, the Penguins bankruptcy. And with that knowledge, it was structured in such a way that it survives bankruptcy. It's out of the lease, so it gets rid of the concern about it being capped and thrown in with the lease. And it's also set up in such a way where it's specifically enforced, and it can't be converted into a money damage type of claim. So it's one of those things that it has all that experience behind it in the way that it was set up.
Why is the NHL not a party to it? And why can't Craig get a copy of the franchise rules to see if the contingency allowing the override based on NHL franchise rules means something significant?
All questions for the NHL. And probably every other sports league as to why they won't enter into arena leases. I've never seen a league do it. Unless they end up owning a team, which now we have two out there.
Well,
The rest of them
it's a
is-
different issue. The issue is there has to be consent from the NHL to make sure that your non-relocation agreement is ironclad, in my view, because there's a specific contingency in the document you drafted that allows for, under certain hockey rules, the non-relocation agreement to be overridden. So why have you not obtained both those rules to assess how unreliable this non-relocation agreement is, or in the alternative, strike that and make them a party so that they will not in any way interfere with the non-relocation?
So it has been since October. I think we negotiated the non-relocation agreement in October, and I can look back and answer this question and get back to you on it. But I'm fairly certain that the reference to NHL rules in there, what it is, if the NHL comes in and tells us, you guys are going to play 2 games in the Czech Republic, which is what they did, it would be a breach of the non-relocation agreement for us to do it. So if the NHL comes in and says, you're going to go and do that, we needed that flexibility. So that's what we were addressing through the NHL rules. It wasn't the NHL can come in and obliterate the whole thing. It was, if the NHL comes in and says, we're playing a home game away in the Czech Republic, we can do that.
Well, Jay, I appreciate that, and you seem like a stand-up man, and you've done some great legal analysis in this. The problem is, as a public interest organization looking at the taxpayer, and as an attorney myself, I can't tell if this non-relocation agreement has any reality to it unless I know the NHL rules that everything's contingent on.
Sure. No, I can appreciate that, and I think that's something that we can follow up with.
Thanks, Jay. Does that sum it up for you,
What kind
Matt?
of non-relocation agreements are in the other sports franchises agreements where they have publicly built facilities, which would be the University of Phoenix Stadium, Chase Field, and U.S. Airways? Have they addressed this non-relocation?
From what I understand, some have them, some don't. Most of them don't, and I think Jay's added value by at least getting the issue to the table. But the problem is, in substance, if the NHL has the ability to scotch the whole deal based on its rules, and I can't tell that just looking at this, it may mean nothing.
So when the Mesa builds a new stadium for the Cubs,
There'll be a very, very strong MLB provision in there that says the exact same thing.
exactly
Very
the same
strong.
as the
Of what Nick's
NHL.
talking about.
And the concern is, in the end, given the power that the NHL
That
has
they
over
will
its
put it
whole
on
team
relocation?
and league,
No,
how do we know that
it's
this
all
means
subject to the MLB rules?
And so I'm curious, for all of you, if from now on, and I heard your interview where you said some of these illegal deals have been allowed to go on because we didn't exist, our litigation department didn't exist. So as the Cubs Stadium gets built then, and this relocation issue exists, will we be seeing you step out with that also?
We are scrutinizing as many of these deals as we possibly can, including the Cubs deal. There is a very significant difference, though, between building an arena, which you guys all did, and sending a check for $100 to $100 million, slightly off there, to a private businessman. If that is a direct subsidy,
just to be clear, that's not
to a team or to a private business, that directly triggers the gift clause and that sort of transaction. If it's a subsidy, or if public funds are being borrowed to facilitate that transaction, that's illegal. It's very different to build an arena. We might not like it as a policy matter, but in most instances it probably doesn't violate the gift clause of the Constitution because you own it, for better or worse in this instance.
One thing you guys said this in the beginning, and I want to be clear about this. You guys are not financing my purchase. Right now, you guys, the city is not financing my purchase. They have nothing to do with my purchase. The city is buying parking rights from us. I may buy a team anyway. I could buy this team and move it to Kansas City.
Well, we have a question on parking rights if we ever can get back to the question that we have.
Just to put this in perspective, we understand what the technicality of the deal is. As you probably know, we have been to the Arizona Supreme Court on a parking garage issue.
I know, I'm not talking to you as a lawyer, and I know you're going to, I don't know the law. I'm telling you as a business person, okay, I'm buying the team. So now what
I know you will own the team, Matt. The question is, how is that being enabled?
They're buying the parking from me as part of this transaction. If I bought a team and I wanted to move it here, right, the economics could be exactly the same. You're just picking and choosing. There are several teams for sale, right? So does this one work? There's a lot of reasons why it does. If it doesn't, let's figure something else out. But I'm telling you, it has not, as I told Darcy, that we are buying the team. The parking deal is part of the lease transaction. It is not part of purchasing the team.
And that is what we are attempting to scrutinize.
Right.
Well, why?
Well, if we can, let's go. We already know this is a point of disagreement here on the parking rights. But can we move back to a couple of the concerns that we have now? We've been an hour and 15 minutes and only had one question answered, and we've got we've got 6 more that we really would like to have answers for taxpayers on. The one that is very important is, when can the public expect to have all the documents related to this sale? You said publicly that everything had been released, and in the months that have followed, we continue to get documents that had not been released. And what people want to know is, when they can expect to have all these documents. What's the truth there?
Well, let's
Okay,
correct
may
your
I
question.
start out by explaining that I am not Document Control Central. Okay, public records requests come in to our city clerk usually. And I know there's some procedure. Sometimes they come to you, sometimes they come to Craig. Whoever is the collector of public records. I know I amuse you, don't I? You have such a look on, every time I speak, you look at me like you just hate me. So anyway.
All I see is a smile.
No, it's not.
It's for the
Okay,
reporter.
so whoever is in charge of collecting the public records then sends messages out to anyone who might have something that fits that particular request. So I receive requests all the time. Do you have anything that matches this particular request? And my staff searches all the records. And if we do, they're collected then to whatever person is collecting them. When I made the statement that offended you so much, the statement was given to me by the city attorney to state. So I'm going to ask him to answer your question directly, because I believe he has an answer as to what was happening in the transition and requests that were cleared afterwards. But I'm going to leave that to him. You're all looking at me. I know you want me to answer the question. That's not the way it works in municipal government.
Well, in particular then, Craig, to you, I mean, why hasn't the city produced to us the raw data concerning attendance, parking, and revenues from the Coyotes that you did produce for your own consultants over 3 months ago?
All right, so let's go back to your original question, because it was you stated it, and I want to correct it because it wasn't a correct statement. All right, we got an email from Mr. Bullock, who said that he had all the documents he needed to do the analysis. The statement that the mayor made, in the context it was taking in, was all the records had. Well,
I'm sorry, that's just not correct. It's not correct. We have had outstanding public records requests with you for a couple of years.
We have the email that says he has all he needs to do the analysis, and we're talking about the analysis.
Yes, but you know the public records request goes.
I'm talking about two
beyond
things, because we were talking about what the mayor's statement was, and that was what the mayor was talking about in that statement, is that the analysis that could have been done long ago, apparently you felt like at that point in time that you had all the records. All right? I'm not disputing that this is an ongoing process. I've never disputed it, and there was never any suggestion that we were done giving out public records. But there is a court process to public records, all right? And I don't intend to sit here with a litigation that you guys filed over public records and have be interrogated by a room full of people.
When can the public expect to have the documents? Is there an answer to that?
And I appreciate if you didn't answer or interrupt. I'm going to answer the question. Or I'm going to make my statement, however you want to phrase it. And I'm glad you're amused as you are when the mayor talks. That's just very polite. But at this point in time, we have litigation ongoing. The lawyers have had long discussions. We'll continue to have long discussions, I'm sure. If we have a dispute, we have a judge that we can go to, and he will dispute it. So far, I think things have gone fairly well, because the process, we're now into, I think, our 11th, 10th, 11th, 12th, I don't remember, filing with the court with public records when they come, when they're being submitted according to the judge's
What
order.
about specifically on the raw data question? You've given it to the consultants. When will the public get the information?
All right. I just told you. I've discussed this with the attorneys.
You've given it to the consultants. When will the public have it?
You asked me a question. You want me to answer it?
Yes, I do. I'd love you to answer the question.
You keep grandstanding. The answer to your question is that I've discussed this with the attorneys yesterday. I'm going to continue to discuss it with the attorneys.
Okay, then what is the answer?
We'll continue to do this in the courts, okay? But I'm not going to sit here and allow you to grandstand for the benefit of the transcript so you can release it and then parade around.
So you're not going to come clean with the public documents, essentially.
That's not
if you've
what
discussed
I said.
it, why won't you tell us when?
You mischaracterized it.
Why won't you tell us when you can give us the information?
We're in the midst of litigation. We'll have appropriate communications along those lines. It's your litigation. You filed it. We'll do it appropriately. And that's the answer to the question.
Okay, so you won't release the documents to the public
today.
today.
That's not true. That's a complete misstatement. A complete misstatement of what I just said. The records are being released. There's thousands of pages that have come out. I continue to go through it. I have sat in this room with these people and explained the process that I have gone through for months, years now, on doing public records. So I dispute and find it highly offensive and take personal offense to the fact that I am not disclosing records, because we are working with a staff. And I would say,
but
Ms.
Craig,
Olson,
you've given the raw data to the consultants months ago. You have it. Why won't you release it?
You can say all you want, but you are costing the taxpayers thousands and thousands of dollars in resources. Nope, I'm not done. Nope, I'm not done. Thousands and thousands of dollars in resources.
Voice, Mr. Tyndall?
I have to, because I keep being interrupted. Okay.
Okay.
And if I'm not interrupted, I don't have to raise my voice, do I?
You guys, what do you want? What do you want?
An answer to the question first.
I've already answered the question. Is that we'll do this because we're in litigation. We'll do it through the litigation process.
What do you want? I'll give you.
We can forward you all the questions we sent to the city, and if you, to the extent that you have the records and can give them to us faster than the city.
Attendance, parking, revenues,
attendance figures,
everything that the consultants had has not been released.
Attendance figures have been given out to the Republic and everybody else. We're gathering and begin to updated ones.
Why
I told
didn't we
Nick.
get them?
Yeah, why can't you give us a
We
now?
asked you for those months ago. Why didn't we get them?
I don't remember
Figures
asking
the
for
Republic did.
months ago. I don't remember any requests months ago. We're getting updated figures. Here's the problem, guys, is now you want to take this into a point where you're making it seem like we're doing something wrong for the purposes of your little transcript here. I got this. I tried to cooperate, Nick. Did I not spend 2 hours on the phones, yes or no, with you yesterday?
2.5, and I
2.5
thought
hours, thank you.
understanding, but I'm hearing today we didn't.
No, we this morning we're working on all the things that we talked about yesterday. All right? We'll continue to do that dialogue. I'm not going to do it here. I'm not going to do public records here.
I'm going to get going a little bit. Is there anything else you guys?
Craig, I want to follow up with that because you have stated on the record.
What record are you talking about? You
The
keep referring to it.
transcript.
It
Sorry,
sounds like it's a deposition.
It's lawyerese. Sorry.
It is lawyerese, and we're not supposed to be doing
I'm going to
it.
interrupt you guys. I'm going to interrupt for a second. I'm going to go. If you've got
Matt,
questions-
can we clear up one thing? I know Darcy's in control of all questions and every comment here, but I think before you go, you should hear this one thing, and she can answer if this is correct. This was March the 16th, 2011. The Goldwater Institute announced on Tuesday that it will file a legal challenge to the agreement between the City of Glendale and prospective owner Matthew Hulsizer to subsidize the purchase of the Phoenix Coyotes once that agreement is closed, which is, I guess, why you want to know if it's closed yet or not. In a statement released by the Institute on Tuesday, Goldwater announced that the challenge comes after the Goldwater Institute examined more than 1,000 pages of documents provided by the City of Glendale under court order. My question before Mr. Hulsizer leaves is, in reading this, my interpretation is you have all the documents that you need to determine that there will be a lawsuit filed and you have made your final decision.
We do not have all the documents, and I think that's what we've been trying to say here, is that
But
you've
you
been
said
withholding
here-
many.
But you said you needed all that you had all that you needed in order to file the lawsuit, so you have made your firm decision. I
That's
would
not
like-
what that says.
Yeah, well, yes, it does.
Mayor, let me
It
clar-
does-
let me
no,
clarify
no,
this.
it says,
Go ahead.
Matt, in a statement released by the Institute on Tuesday, so I need to find that statement, I guess. Goldwater announced that the challenge comes after the Goldwater Institute examined more than 1,000 pages of documents. You may want
Right,
more
what that
documents,
means
but
is you
have
finally
made-
gave us, it doesn't
you
mean
have-
we had everything. It
you-
doesn't state
no,
that.
No,
we
I'm
never
not saying
did.
that. What I'm asking you, and when I read this, you issued a statement that you are going to sue as soon as the bonds are sold, and I'm asking you for verification of that.
If the mayor, if the deal is not changed, yes, we have concluded based on the documents that we have that it is illegal, and we will sue. That's exactly what we said. We
But-
hope that the deal will be changed.
And to clarify, we understand that there are still other documents out there. So we don't know what those documents are, what they could say, and certainly they could potentially affect our analysis.
You know,
Let's
like,
take a
did
short
you-
break here so I can say goodbye.
Thanks, Matt.
All right.
Good to see you. Thanks for back.
All right.
Thank you, yes. Safe
All right.
travels. Thanks, Matt.
All right. Nice to meet you.
You too.
All right.
See you back to Chicago?
Yeah.
That's where I'm from.
All right. Thank you very much. Are you really?
Used to work for the city
later,
later.
Jay.
Oh, really?
Yeah.
Things are getting better there.
I know.
I know,
I
right?
rolled in and I was like, oh, I'm just glad you're not wearing a purple shirt.
You guys know what's the guy from The Simpsons? Mr. Schmidt. What's the guy's name? You guys think about The Simpsons?
No.
Mr. Burns and his assistant.
Oh, Smithers. Smithers. I love it. I love it.
No, sir.
Slow down. Well, it's going to be a lot of editing. The city orders your plans, like the city.
No, we did.
Oh, no.
Yes,
I don't
like
know.
over me and
Make
so
one
we're going to get the
comment.
transcript to use as possible. There's just that there's going to be a lot of editing going on. Sure. And I'll have to
I think we need to meet Ellen, actually. I do too.
And it's going to take
I'd like to make one
Are you taping as well? Yes.
comment.
Okay. Is your 2-3 report? What is it about?
Now I know. I usually do depositions and I
Are you
know.
returning?
Yes.
Okay, good.
Yeah. So that's why I kept looking at you like I know that you're not. And when I take deps, you're the like corporate employee. So
No.
yeah. So what I would typically do is
Sorry.
Trying to get a word in edgewise on that.
in a deposition, you would be telling people to slow down, and I understand this is a different format. So,
Nick.
but I think that you should speak up because no one's going to try to bark at you. If I do that, I just get barked at.
Are we done?
No, we got just a couple more minutes. I think we've got a last question. They might also have another question.
I mean, if you can.
Oh, yeah, definitely.
Should be interesting. So I guess that's the only thing that will trump representatives, right? Congressmen.
So resuming the Cupcake Summit. Craig, I just wanted to ask you a question that I really wanted to ask you for a long time, but you just went through a discussion about the spirit with which the city has produced documents according to court rules and so forth. What about the email that you sent to my colleague, or that was inadvertently sent to my colleague, Carrie Ann Citron, instructing your deputy, saying, and I quote here, "There's no law that says that we have to be clear," and then concluding with your instruction, "I'd play with her or ignore her in the context of a public records document."
What else? Go on.
You have no answer to that, Craig?
I have no answer to that. It's ridiculous to bring it up. It's bizarre that it would even occur.
It's not bizarre because it's
you got a problem
part
with
of
public
a
records,
pattern
take it up
of
to the court.
practice.
Take it up to the court. You got a judge?
Definitely
take it up to the judge.
plan to do that,
Take it
Craig,
up with
but
the judge.
for purposes of the public understanding what we have had to deal with in trying to get documents.
Take it up
from-
with the judge. Right? You got a judge. Take it up with the judge.
I think.
Go
through. I think we're done. I think we should finish. Would you like to answer these questions now, or would you like to finish? Okay.
Before we
ones
go
that I
on,
can-
Mayor, would you like to see a copy of this email? That
No, I've seen it.
You have seen it. So you've seen the disrespect that was shown by Craig
I
to
dispute
my
that.
colleague.
I dispute whatever you're saying on that.
You've seen that, correctly?
And you know that the city is under a statutory obligation to provide
Of course we
public
do.
records.
Of course we do, and we abide by it at all times.
Do you stand by your city attorney's conduct in
You don't
this
have to
case?
answer that, Mayor. This is not a deposition. This is ridiculous. It's a ridiculous tone to even
Well,
take.
ignoring public records requests is ridiculous.
I've never, Carrie Ann, ignored a public records request. Never.
You
You've
simply
instructed your colleagues to do that?
I've never, it's not what it says.
All right.
Wait, hold on.
All
I just
right.
want this- So I play with her or ignore her. What does that mean exactly, Craig?
Keep going if you want, Nick.
What does it mean?
Keep going if you want. And you got a judge. Take it up with the judge. You got a problem with public records, take it up with the judge.
Well, see, this-
Okay. It's okay. Let's.
Can I
Yeah.
I just want to say, we did have a conversation, Mr. Tyndall, and about the public records, the ongoing public records requests and the issues we've had. And we asked you to make representations, like, are there more documents, or have you produced everything that's responsive? And what you told us is that I'm not going to stand by anything. I am not going
That's
to
not
give
what
a
I said.
commitment to you. Excuse me.
No, that's not what I
Do
said.
not interrupt me. It is not nice.
You
See, there you
misquoted
go.
what I said.
Okay, are you done? Can I finish?
You misquoted what I said.
You
So
were
as long
not
as you
going to
misquote what I said,
come on.
As long as you misquote what I said, I will interrupt you.
Okay. Will you sign a document under oath saying that the city has produced all documents responsive to our requests?
The city is producing all documents
Okay.
in accordance with the Arizona statute. In
That's not
accordance with the
responsive to
court
my question.
order, in
So-
accordance with the court order. And so I think your request is illegitimate and inappropriate.
I'll take that as a no.
Well, you'll take it as what I meant it to be and what I said.
When can we count on your representations? If we have conversations about the
Take it up
status,
with the court.
can I ask my question? Can I
Okay.
get the whole question out before you respond?
Probably not.
We would like to know. Probably not. Did you get that? Okay.
All right.
Well, then I
Let's
guess
just
there's no point in me
stop.
even attempting to ask.
Yeah.
All right, good.
Okay. So do you want to do? We covered some of these, so this is the one.
In particular, in our questions, we referenced a January 25th, 2011 document where the city signed a contract with the developer of Westgate regarding parking rights. Really, there's two questions there. Why did we have to find that on our own when it is so clearly relevant to the issues that we're trying to resolve? And second of all, what's the deal?
I dispute your clearly relevant statement. We talked about it yesterday at length. You got a judge, Clint, go take it up with the judge.
Now, let me just read into the record what we're talking about. We're talking about a January 25th.
Reading into the record sounds like an interrogation or a deposition. Is that what we're doing?
This is for the benefit of everyone to understand what we're talking about. We're talking about January 25th, 2011, First Amendment to a mixed-use development agreement between the City of Glendale and the developers of Westgate. And what's especially significant about this document is how at page 10, paragraph 9, it specifically says, quote, the city shall be entitled to impose parking charges for the use of all parking spaces for arena events. And it goes on to say that it can retain all such revenue. And now this is in January of 2011, the city is acquiring all of the parking rights relating to the arena. And this document wasn't produced to us. Why is that?
Take it up with the judge. We have litigation.
Okay.
In the midst of litigation,
Are there
take it up
any
with the judge.
questions you would
Okay,
like
so
to ask
we
me?
can we
that
do
I
that.
can
Can we just
answer?
follow up on just that one part of your answer that from the City of Glendale is take it up with the judge in terms of producing documents. But since we're also here to exchange information on the impending deal, we would like you to explain to us what that means so that we can understand the parking rights issue.
Spent 2.5 hours doing that yesterday.
No,
with you.
we didn't get
And
an
I think you have all the
explanation.
documents. You have all the documents. Yes, you did.
This isn't a document question.
You
This
had
is an
all kinds of
information
documents.
question. This is not a document question, Mr. Tyndall. We're not asking you about the documents that we'll have to go to the court to get from you, apparently. We're asking you to explain,
Incorrect.
excuse me, we're asking you to explain to us what the contract means for the City of Glendale and the taxpayers. That is what we're asking. Can you sit here today and explain to us what the January 2011 document means in terms of the city's parking rights?
As we sit here today, no, I don't know what that I don't know that document enough to explain that to you. I didn't.
Would you like to look at it?
No,
I mean, do you want
wouldn't.
some time to look at it?
No,
Okay.
I wouldn't, because that's not the purpose of our conversation here today, and that's not why I came here today to try and.
Okay.
So no, I don't. But thanks for the offer.
Great. Well, maybe you could send an explanation later, since you had mentioned that you had talked about it yesterday. So that would be helpful to us.
I
And
thought
then
I'd provide
I did want to go back to one of the questions where we talked about Jordan Rose and her statement to us, because apparently yesterday Craig suggested that the city, to our attorneys, that the city never intended to sue us. But as we've said before, the press has widely reported this, and on March 5th, your outside attorney sent us an email saying, quote, tonight the city decided that they could do nothing but to bring a lawsuit against GI, board members for several $100 million. And the question is, did your outside attorney correctly represent what occurred?
Well, let me answer it this way. Whether or not the city will go forward in litigation is something that the city will decide and has the ability and right by statute to decide in confidence. So my comment yesterday, which you mischaracterized, was I think there was a statement, I didn't write it down, I wasn't doing it.
Must have been misunderstood.
Was that the 30th threatened to sue. I said, hold on, I don't think the city's ever threatened anything. I don't think the city's ever threatened to sue the Goldwater Institute. That's been reported in the papers.
Well, that's
I can't
what your
help with the
attorney.
paper.
That's what
Right.
your attorney said. That's why I'm
So-
asking. That's why we're asking you. Is that an accurate representation?
May I speak? And
Yes, please.
If I'm going to be in violation of the open meeting law,
Stop it.
hit me or something. I was very surprised at how this particular statement was taken out of context and blown up primarily by Ms. Rebecca Sanders of the Arizona Republic. What the city council was presented with was the possibility of such a thing occurring in the future, that the situation might be such, and this was all in executive session, so that's what I'm telling him. If I'm going beyond what I should say, I need to be stopped. That's why I have my attorney here.
Just don't go too far, I suppose.
Okay, so the discussion was a general discussion in executive session that there might be a situation in the future where that would be an option. The city council was apprised of that. somehow this whole thing then went.
Well, by your attorney said
And
that.
I cannot.
We can give it to you.
Ms. Olson, I believe you have it in print.
Mm-hmm.
I've never seen it. I never authorized that attorney. I am not questioning you. Would you listen to me? Okay. I believe that was in print somewhere. I did not authorize her to say that, and I would say that is an incorrect statement.
Thank you. Thank you.
Mayor, would you like to see it? Do you have an interest in seeing it?
I don't see why it would make any difference.
I'm not disputing that it occurred. You're going to give me a piece of paper that I will read at some point, and you're telling me what it said. I believe what you're asking me was, did I or the council direct her to say that? And I am saying no.
Great.
Let me just be clear on this one point, because, Mayor, I appreciate your willingness to clarify this. I think you've done that, but it is a great concern when an agent of a public body, like a city, engages in threats of litigation over the exercise of First Amendment rights. And I want to read into the record the exact thing that the city's outside attorney said, and I'm going to quote it. It says, quote, "Tonight, the city, and I've heard but not yet verified myself, the NHL, decided that because GI," apparently meaning Goldwater Institute.
Where am I in this? So I can follow you, because it's a lot of writing.
It's right towards the sixth or seventh line down from where it says Tom. I hope all is well. And I'll start it over. It says, "Tonight, the city." And
Wait,
I've
let her
not-
find it.
Okay.
Got it.
Do you have it, Mayor?
Yes, I do.
Okay.
Thank you.
"Tonight, the city, and I have not heard, but have not verified myself, the NHL, decided that because GI will not answer calls, emails, accept meetings, outline their specific legal concerns with the deal, there was nothing left that they could do but to bring a lawsuit against GI board members for several $100 million. Please know that I have stepped away from this, as I will have nothing to do with this litigation, as some of my best friends are your staff. That said, I think Skadden out of New York and Fenimore here are working on the suit now."
So, what I can tell you in generalities, because it was a conversation in executive session, was that based on the financial harm that will be brought to the City of Glendale if we do not, that there may be situations and conditions under which the City of Glendale should consider a lawsuit. We did not make a decision to sue at that time, but we did understand that this might be coming back for further discussion. I believe that's general enough.
I will say that the city regularly discusses its rights and remedies under in the executive session under Arizona statutes and various transactions.
Great.
I
Well, we
believe I
appreciate-
said something in my press conference that alluded to that. Is that correct? I'm trying to remember what my statement was, but when we had the press conference at the state, no. I don't know where Rebecca Sanders got this from. but
I'm sure she
before-
got it from Jordan.
Okay.
Yeah.
Before I knew it, I'm reading on azcentral.com that not only are we suing, but there was a deadline on which we were going to do this, and the next thing that happened were those incessant phone calls of, why haven't you sued? You said you were going to sue on Monday or Tuesday, whatever it was,
Which nobody ever said.
which we never said. And
Why wasn't there any attempt to correct the record?
well, Ms. Olson, I'm going to tell you in all honesty that there are many attempts to correct what Ms. Sanders says, and they just never
Not what she
appear.
said, what your attorney, Jordan
I
Rose,
am
said.
seeing this for the first. Please, can we talk in a more civil tone? I've met you one time, and you really are very.
For the record,
Your
I'm
manners-
seeing a very civil discussion, and this is an effort to pad the record with comment.
No, it's
No,
not. No,
I
it's
dispute
not.
that. That's-
There
that's
was quite a
inaccurate.
bit of discussion in the press about unless people see each other's face and whatever. I'm trying here to answer the questions that I have answers to. I'm offering you information, and you're giving me eye
Mayor
rolling
Scruggs,
and
this
so forth.
isn't personal.
She's
for
making
any
it
of us.
personal.
I can
She's
assure you
making-
it's
Certainly.
not.
So
it's
the
not
question,
personal.
the question
Yes,
is,
it
the
is.
question
It's
is,
not personal
why
on
was
our
this
part.
not
Yes.
refuted?
Yes.
And I
You're a
will.
public servant. Don't forget that.
It's personal. You
Public
made it
servant,
personal.
Craig. Don't forget it.
May
I've never
I
forgot.
say this so that
And
she
it's
can
not-
hear it?
Let's let the mayor
Excuse me.
answer
Yes, ma'am.
this
Go ahead.
question.
The question is, why was this not refuted? I am seeing this for the very first time since you handed it to me today.
Okay.
I didn't see it in a newspaper anywhere, and it sounds like Jordan Rose is trying to say she wants no part of this, is what I'm reading into this. Is that the way you're reading? Or I'm not supposed to ask you questions, but I have not seen it before. Have I
Okay.
answered your question
Yes, thank you.
satisfactorily? Thank you.
Thank you.
Okay, what's
Well, we
next?
appreciate your time today and the opportunity to share some of the suggested ideas that we have for possibly helping resolve this ongoing dispute, really, about how best to settle things with the Coyotes and the City of Glendale. Do you have any other questions for us?
I do. I would like to know, in providing to us one possible solution, not the whole thing, but one possible solution is partnering with the Tohono O'odham Nation, in what form you would see that.
Actually, it's all we know is that some sort of offer has been made, at least to discuss this. It's our understanding, and please correct me if I'm wrong about this, that you have not been willing to sit down with them to discuss this as yet. As you know, a lot of pressure has been put on us and you to get together and meet. I would hope that the city would explore every possible option to get the taxpayers off the hook and keep the Coyotes. So we don't know what they have in mind. We haven't really any idea other than what we've read in the newspaper. But it seems to us that it's worth exploring. And obviously, you have to make that decision for yourself.
Out of fairness, may I have an opportunity? And some of what I will say is repetitive, but I think it's very important because this is one of the least understood issues that is going on in our state right now. First time this idea was brought to me was, I'm going to say a year ago. Maybe it was 13 months, maybe it was 11. So let's just say a year. And it was brought by an individual, private party. And they see me as kind of like the one controlling this whole Tohono O'odham situation, when in reality there's a whole series of other parts to it. And he said, if I would just remove my opposition as one person, the Tohono O'odhams would pay $100 million to somebody. I'm not sure who it was going to pay it to. And all my problems with the Coyotes would go away. And I said, you are asking for something that's not even legally possible to do. Number one, we have a city council that passed a resolution, April 2009, opposing the creation of an Indian reservation within our city. So that's the basis here. So that would have to be overridden. Everybody would have to change their mind. And we talk about this very frequently. And there is not a majority position to change our mind. Secondly, we have reached out to Tohono O'odhams on numerous occasions saying, you own all this land within our city. If you will develop, as anybody else will develop, we will partner with you. Probably that would involve incentives, which you'd have to investigate at some point. But anyway, but if you will develop as everybody else around you has developed, as a part of, the state of Arizona, United States of America, whatever, we will work with you. We want you to develop your land. We want you to have economic prosperity for it. They are unwilling to do that. They will only develop if it is taken in as an Indian reservation because they want the casino. That's the only thing that is of any relevance or importance to them. So that then runs them headlong into the Attorney General and the State Gaming Compact and IGRA, the Indian Gaming Regulatory Act. I don't know how familiar you are with that. So the creation of an Indian reservation, first of all, they're nowhere near, they're on the Aboriginal lands of a totally different nation that finds great offense in all of this. Okay, so it is totally in violation of all of those other, the federal law, IGRA, the state gaming compact. It is also something that causes other Indian nations to have written letters of opposition, passed resolutions in their tribal councils, and in the case of one group, to start a lawsuit, and another nation has asked to meet with us that we believe wants to join the lawsuit. So this is not, it sounds so easy and simple, but this does not turn on the City of Glendale's lawsuit that we do not want an Indian reservation within our city. It goes far beyond that. So the partnering now, in the last couple of weeks, had some really interesting phone calls from business community members. I've also heard from a member of the congressional delegation who was asked to approach me, and after learning I was approached, said, "There's no way. This is inappropriate. This is blackmail, is what it is." So, but I did meet with one small group of local West Valley elected officials, because they said, even though you've told us how you know, all of this, we think we should meet anyway, because losing the Coyotes means problems for Westgate, and that's problems for all of the West Valley cities, because we're kind of the front door to the economic development of the other cities. So I sat with them for close to 2 hours, and I produced all of the documentation. They were just kind of stunned by it all. I produced the letters of opposition, the resolutions from the other tribal nations. I produced Tom Horn's letter. I can't even remember, I'm sorry, I had a thick stack, our resolution and so forth. And I said, this is what you're looking at. It's not as simplistic as tri-advocates would like you to believe it is. So I just really want to get this on the record, because I have been dismayed, to tell you the truth, that it was January 28th, 2009, that I was, after about 3 weeks of being asked to attend a meeting where nobody would say what the purpose was, but because of a relationship between a member of my staff and a member of Tri-Advocates, I said, okay, I'll go. And so this was presented the day before they filed their petition with the Department of Interior, and I've been just kind of astounded at how the entire story is not allowed to be given out for the public to understand. As the public begins to understand this, and begins to understand what a sovereign nation is, and that all rights are given up. And let me tell you just simple things that I brought up to Chairman Norris, that, you know, I was presented with this as this is going to happen no matter what, and so I wanted to make the best of a bad situation. And just simple things that I asked him about. The fact that they're in the flight path of the Glendale Airport, and they would not have to abide by FAA rules regarding heights, placement of buildings, so forth and so on. Would you abide by FAA rules? We'll talk about that after it's taken into trust. Well, how about Luke Air Force Base? Because where you are can cause interference with Luke Air Force Base's airspace. Will you comply with Arizona state laws regarding compatibility of uses that relate specifically to Air Force bases? We'll discuss that after it's taken into federal trust. Well, Chairman Norris, you know, we've been working for years to build the Northern Parkway, which is the only avenue left, really, corridor opportunity left for east-west traffic in the West Valley after the Paradise Parkway was taken away. We're past 35% design right now, and it will go right because it's right along Northern Avenue, which is the northern edge of their property. Will you agree to abide by the design as it's been put together by Maricopa County, El Mirage, Peoria, Glendale? I can't remember if Surprise is in there. It's a multi-jurisdiction. Mm-hmm. He says, well, actually, we don't like where the off-ramps are. We'll need to talk about that. Chairman Norris, what about water and sewer? Well, we'll allow you to bid on water and sewer if you want, but if we don't like your prices, you know, we're a sovereign nation. We can just drill wells. This is in the West Valley where no one can drill wells, where there are serious issues regarding the drawing down of the aquifer, but they will do that. There were several others, but these are kind of the main ones that stick out in my mind, where there was an absolute unwillingness to cause anything that resembled assurances or reassurances that they would be community partners. And I'm only telling you this because it goes to what our opposition is. Our opposition is to the creation of a sovereign nation within our boundaries. The state's opposition is to the violation of the state gaming compact. The Indian nation's opposition is due to what they see as a breach of trust among the 17-nation agreement that led up to Proposition 202 in the year 2002. Thank you for giving me. I know I took a lot of your time.
Well, Mayor Scruggs, we have simply attempted to give you some ideas that may help find a solution to this. Obviously, it's up to the city whether it explores those possibilities or not. The one thing that we will offer is if the deal is changed, and you asked me before whether we were committed to filing a lawsuit, and I replied that based on the current deal, we are, unless we find something that we don't know yet that would change our mind. But we are very happy to look at any changes in the deal and to give you our thoughts on them. And we hope that the city will do everything it can to put together a deal that comports with the Arizona Constitution.
We probably have about 3 or 4 days to do that. Before
Is that your timeline right now?
I'm just guessing. I don't know. Nothing has been given to us formally. But in reality, most of what you have suggested would take sort of going back and starting over. And I don't know. You think we have that kind of time?
Well, I don't know. You just mentioned 3 or 4 days. I don't know what
and
you're
I
talking
should,
about.
for the record, let me say that I made a flippant offhand remark that I probably should not have. I believe that there's, as Commissioner Bettman says, there's not an infinite amount of time. And there has to be agreement by Mr. Hulsizer and Mr. Bettman. So I apologize to each of you for saying 3 or 4 days, and I ask your indulgence in not saying Mayor Scruggs said 3 or 4 days. I've tried not to be flippant through this meeting at all, and I erred.
You got it. No problem.
Thank you.
Great.
Thank you.
You bet.
Thank you.
Thank you.
Thanks for coming over. 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 Thanks for coming over.